I think we can get started now. Good morning, everybody. My name is Romy Jurado. I'm an attorney here at Jurado & Associates. We're a law firm and we practice in many areas of law, of course, including real estate, business, probate, estate planning, litigation, trademarks, copyrights. Today's class, Shift to the 21st Century, how to market appropriately, following the ethical guidelines and not getting into trouble. So, shift to the 21st century, marketing for your business, doing it ethically. Consumers want to know, right, whether you are the right person to guide them through what is likely the biggest purchase of their life. So buying a home is probably the biggest purchase of your life. Your logo, your photos, social media profile, business cards, websites, and testimonial all are going to work together to project your value statement to consumers, right? You need to not be deceptive. That is very important because the FTC regulates that. So besides even you as a realtor and being regulated by FREC, you also don't want to violate any federal consumer protection laws when it comes to advertising. And we're going to talk about that in a minute. So advertising laws for realtors in Florida generally, right? So ads for agents do not have to include a telephone number unless the brokerage office policy requires it. However, the license name of the brokerage firm must appear in all real estate advertisements. This is something that I actually see a couple of agents not doing. They will have like their team name, right? And they'll start advertising with their team name, but not include the name of the brokerage. That's actually not correct. Now, while you may have a team and your team is probably the name that you really like, you are an agent and you're working for a brokerage and you have to disclose that. You have to disclose the name of your brokerage. You could include your team name. You could even trademark your team name so no other realtor uses that team name to promote real estate services all over the United States. But you are not working under that team. It's not a company, it's just a name, and it's not a brokerage. You're working under your brokerage, and that must be included in all advertisement. That, of course, includes social media. Many agents, for example, use nicknames. If they wish to use a nickname in advertising, they should include it in question marks after their first name or first initial. You don't want to trick people as to what your real name is, because that could be an ethical violation. It could also be false advertisement, and you could be violating the Federal Trade Commission's rules. So if you have a nickname, that's all great and dandy, but put it in marks and quotation marks so that people know that's a nickname and it's not your legal name. A licensee may share brokerage conversation with a party to a transaction as long as full disclosure is given to all interested parties, right? So that is some regular advertising laws. The Florida Real Estate Commission, FREC, they have certain rules regarding advertisement. So all real estate professionals must adhere to FREC, right? You're a realtor, you must adhere to FREC, to the Florida Real Estate Commission, and you also must adhere to any other consumer law that might affect the people that you're serving. In this case, people buying houses or people buying commercial property. Usually it's going to be people buying houses. So FREC advertising rules apply to all advertising, including social media and online ads. I was talking to an agent the other day, and she was posting on a group, like in a Facebook group. She was advertising her real estate services, but she never disclosed who her brokerage was or anything like that. That is still advertising. You know, even if you sent it in a WhatsApp chat, that's advertising. And you put it in a Facebook group, that's advertising. If you're putting it anywhere, if you're putting it out to promote your services, that is advertising. So you have to adhere to those rules. Just because it's a private group doesn't mean it's not advertising if people from the public can essentially join in. Now, of course, it's not advertising if you're talking to your family, maybe, but if you're putting it on Facebook groups, you must adhere with, the FREC rules and any other consumer protection law rule. So social media ads are defined as ads for your services, listings, etc. All advertising must be in a manner in which a reasonable person will know they are dealing with a real estate licensee. All ads must include the name of the brokerage firm. There are certain positions where the information must be. For example, with advertising in the internet, the brokerage firm name must be placed adjacent to or immediately above or below the point of contact information. The complete brokerage name must be listed. So I was telling you that a Facebook group post is an advertisement. So you can't just put your picture in the house that you're selling and the price. You have to disclose the brokerage name. Okay, and where is the brokerage name? Where is it going to appear? Are you going to hide it somewhere nobody can see it? No, it must be placed adjacent to or immediately above or below the point of contact information. Another situation that we have is licensed realtors, right, promoting their property and not disclosing that they're realtors. That is also a violation of the ethical rules. Why? because if you're a licensed realtor, even if you're not listing your property, right? So you're going to sell it on your own. There's actually a form, part of the contract that you have to use, which is called disclosure of an interested licensed party, whether you're the seller, the buyer, or if you are connected somehow, even if it's your family member or if you own it to an LLC, you have to disclose it at the point of contract. But you also have to disclose it when you're doing advertisement. So where any reasonable person would know that you are a realtor, even if you're not listing it, right? You're not listing it in the MLS. So I saw a couple of violations of that. We actually used that to get out of a couple of contracts. There were, different realtors that were basically coming against people who have lost a family member and they own property, right? And they would go to them pretending that they wanted to buy the property for themselves, when in reality they were licensed agents and they wanted to basically get other buyers of those properties. These people had gone through a loss because it was, they lost their mom, their dad, their uncle, so the property was there. They were tricked into thinking these people were actually buying it for themselves. At the end of the day, they end up signing a contract that was actually assigned to somebody else, and then they realized, wow, I'm selling my property for this much, when in reality this property is worth a lot more. I want to get out of it. So of course the agents don't want them to get out because they're like, you signed the contract, but hey, it was fraudulent inducement because they didn't know that you were an agent. They didn't know that you would have, basically kind of tricked them into it. So you can use that. Well, in our case, we use that to have our clients get out of those contracts. So you do need to be honest, right? In a matter in which a reasonable person will know that they're dealing with a real estate licensee, even if you're not listing it. If you're going to people and you are a licensed agent, they have to reasonably know that you are, even if you're not going to put it on the MLS. All ads, all ads must include the brokerage firm and in a certain position. Remember, you cannot hide it. Also, the registered broker must maintain a current written record of every team or group member. If a team has a website, it must be clear to which broker they're affiliated. So it's agents, so it's against the rules to only have the team's name on the website. This is also a violation of FRAC. So yeah, you may have a fabulous team name that you love, and it's great. You even hire me to trademark it so nobody can use it anywhere in the United States to sell real estate services. But in that website, if you're not putting the information of your brokerage, you're already violating FREC rules. I would even go as far as saying in your Facebook page that you created for that team, if you're not disclosing that you're part of a brokerage, you're already violating FREC rules. And people ask me, but Romy, I really just want to put my team name. I don't like my brokerage name. Why do I send them clients? I want to have it only for my team. Great. Then open up your own real estate brokerage under that team name. And that's actually something we can assist you with. So if you want to operate under that name, make it your brokerage. If you want to operate under that name, but still receive all the services of a brokerage as an agent, that's okay too. Just make sure that's properly disclosed in your website. And I would say in your, any type of social media profile that you're using for your business, disclose that you are with this brokerage. So that won't be a violation of FREC rules. More about multiple offers and code of ethics and standards of practice. So for example, buyer and seller, right, agents need to handle multiple offer situations carefully to avoid accusations of negligence or preferential treatment that violates federal, state, or local fair housing laws and ordinances. When representing a client involved in a bidding war or multiple offer situation, there are many ways to help your client help themselves. Make sure they have secured, stable financial backing, help them craft a competitive offer, and let them know some practical options that may sweeten the deal, like a quick close. However, remember that your client's best interests are always number one, and it is your job to be the voice of reason in an emotional bidding war scenario. Seller disclosures. Agents and brokers need to follow their state laws and the code of ethics with regards to seller disclosures. About the conditions of a home, seller must be able to disclose any issues that come to mind when listing a property. As a real estate agent, you are held to a higher standard of honesty and full disclosure. Any breach of this duty, whether for negligence or intentional action, it's subject to the risk of a lawsuit. Always document everything and be honest at all times. So let's talk about seller disclosure. And I know there is a new flood disclosure that became effective on October 1st. So in the litigation side of our practice, we will have, people that bought a property and maybe a month, 2 months, 3 months went by, and that's when they start realizing like certain bad things with the house. So they come to us and they're like, look, we bought this property and now look at this, there's issues with mold. There's issues with the water under the house. There is issues with electricity. I mean, all these issues come up, right? So the first thing that we do as attorneys is we ask them, let me see the contract. Of course, it's going to be an assets contract. Let me see the seller disclosures, and let me see any type of inspection you did in order for you to buy the property. So inspections. Now, while I recommend everybody to get an inspection when buying a property, clients are misunderstanding that an inspection is insurance. It's not, right? So an inspection might cost, depending on the house, 400, 500, 600. They're giving you a report that tells you what can potentially be wrong with the house and what needs to be fixed, but it's not insurance. You're not going to be able to go against the inspector and say, look, you didn't disclose this in your report, so now you need to cover it. It doesn't work like that, because if you read the agreement that they sign with the inspectors, they're releasing them of any and all liability. And if you look at the actual inspection report, it will say that same thing, that it's just for informational purpose. They cannot rely on it. So while I still recommend to do an inspection, I try to explain to clients that it's not insurance. You're not getting insurance and nothing's going to be wrong with the house for $400 or $500. It's just not going to happen. So what should they do when they get an inspection report, right? You guys as realtors should not be the ones explaining to the buyer what the inspection report says. That's not your job unless you're a general contractor. That's not my job either. I am not a general contractor. So what do I do if I'm hired to represent the buyer and they have an inspection report? I send them to speak to general contractors. With the inspection report at hand, they can speak to a general contractor to understand the report, and the general contractor can even go to the property to inspect themselves and give them an actual quote. That, I think, is the best thing to do, and to safeguard the agent's liability, the realtor, because now you are not the one explaining the report. A general contractor, somebody that has a license, is, and that way the client can get, 1, 2, 3 quotes for what it would cost to fix the property, and you're not going to be held liable. Because when they come talk to me, months have passed, they'll tell me the realtor is the one that ordered the inspector. The realtor is the one that explained the report to me and told me it was not a big deal. Told me that little, thing that I saw in the wall was not a sign that there was a flood, that just needed a couple of paint jobs, and that's it. The realtor told me there was nothing wrong with the sewer. They will throw anybody under the bus, right? That's how it works. So that's why don't get involved in explaining the inspection report as a realtor. Let them talk to the inspector if they have questions. Let them talk to the anybody that does general contracting work, and let them do all that, so that way they get the information that they need, and you're not the one that's providing it to them, because then that's assuming liability. When it comes to seller disclosures, sellers need to disclose certain things, but if they don't know, then they don't know, right? So when you, as an agent, now you're already helped the buyer in another transaction, now you're helping the seller, or maybe you're helping both in the same transaction, right? You can be a transaction broker. Do not do the seller disclosure for your seller. I had situations on the litigation side where we see it and they tell me, Romy, I didn't do this seller disclosure. The agent did it for me. I don't even speak English, so I don't even know what that says. Don't do that. As an agent, you should not be filling out the seller disclosures, not even if they tell you to do it. No, I'm too tired. Just put no everything. Don't do it. You're assuming liability. You're asking liability for yourself, and you're asking liability for your brokerage, because whatever you do, your broker is responsible of, because you are their agent. So do not do it. The seller disclosure should be done by the seller. If they don't understand, they can hire an attorney that explains it to them, and then they can do it. But they should be doing it themselves. Now, there is a new disclosure. Let me see. Oh, and if they don't know, they should put they don't know. They should only put no, and this is important. They should only put an answer no if the answer is really no and they're 100% certain, okay? Otherwise, the seller is assuming liability. Because if they don't know, they don't know. Don't have them just put no if they don't know. I don't know how to make it more clear. Let's see. If you put you don't know as a seller, then me as an attorney, I can't sue you for something you didn't know. But if you put no, then I could sue you because you lied to me. You should have known. Be careful with that, okay? So just, if they don't know, they don't know. If they do know, then fine, put no or yes. But if they're not 100% sure, do not make those statements. And there is a new disclosure right here that I'm going to put up. I think I see a question. 1 second. Okay. No, that's our contact information is in the chat. So feel free to get it from there. And I just want to bring to your attention this new flood disclosure that just came up. It's one of the required things that you have to do, right? So they have to disclose whether seller has or has no knowledge of any flooding that has damaged the property during seller's ownership, right? Let me see if I have it, of the property. So let's say your seller, do they know whether there was a flooding or not? If they don't know, they don't know. And it says during the ownership, right? So they have to disclose. Seller has or has not filed a claim with an insurance provider relating to flood damage on the property, including but not limited to a claim with the National Flood Insurance Program. Seller has or has not received assistance for flood damage to the property, including but not limited to assistance from the Federal Emergency Management Agency. For purposes of the disclosure, a term flooding means a general or temporary condition of partial or complete inundation of the property caused by any of the following: the overflow of inland or tidal waters, the unusual and rapid accumulation of runoff or surface waters from any established water source, such as a river, stream, or drainage ditch, sustained periods of standing water resulting from rainfall. So there is now a required disclosure, and just came up. New laws usually come in June, and now this one is effective on October 1st. So seller must disclose. If you're representing the seller, inform them of what they need to disclose. If they don't know, they don't have the answer, then they will put I don't know, but do not tell them what to write. They need to make those decisions on their own by themselves. So what type of defects must be disclosed? Any material defects that threaten the property structure, or interferes with enjoyment must be disclosed. These defects include, but are not limited to, the following: permit code of violations. The inspector must make sure the property is in accordance with the county regulations and possess updated permits. If seller knows of any violations of code, then they need to, let the buyer know. Any water issues during the inspection, buyer must be made aware of any water damage problems with plumbing, non-working septic tanks, and more, right? So if the seller knows, they need to disclose, especially with the new flooding disclosure. Structural issues. During the inspection, buyer must be made aware of any shoddy remodeling or construction, underlying structural problems not readily observable, right? And any wiring and electrical issues. All those things, if the seller knows of it, then they must disclose. Fair housing, right? So fair housing issues can also arise wherever buyers feel they face discrimination because of race, ethnicity, gender, age, disability, religion, or other protected class. It's not just seeing a buyer's name that can lead to potential fair housing violations. Sellers can decide not to sell to certain individuals after looking at their social media posts or securities video when prospects tour their home. It is important for agents and brokers to be clear and transparent with buyers, clients, to be sure they feel they have been treated fairly, and to document those conversations. No person or party should plan or agree to discriminate against a person or persons on the basis of race, color, religion, sex, handicap, familial status, national origin, sexual orientation, or gender identity. So now a seller can refuse to sell to whoever they want, right? But they cannot do it because of a discriminatory reason. Also, landlords can do it, cannot rent, but they cannot do it because of a discriminatory reason. And if you are made aware of this discriminatory reason and you participate in basically that violation, you can be held liable too. So be careful with that, right? You cannot discriminate, sellers cannot discriminate based on race, color, religion, sex, handicap, familial status, national origin, sexual orientation, or gender identity. And neither can you if you find out the seller is. So be really careful with that. Agents and brokers need to guard against wire fraud scams. That could cost the buyer or seller hundreds of thousands of dollars. The title company should be encouraged to speak directly to the buyer to provide wiring instructions. Also, the client should be able to call the escrow agent or title company directly before sending a wire transfer. There's a growing number of wire fraud and other scams stemming from compromised business emails. More than 552,000 people were victims of wire fraud in the real estate and rental sectors in the last 5 years. Do not give or receive wire instructions. I don't care how secure you think you're being. Have the buyer deal directly with the title company. Have them verbally confirm the numbers. There is just so much fraud out there. Okay. With AI, they can copy your voice and make it sound like you. With emails, they can make it so that they receive an email from your email and you're not the one sending it. Through technology, they can text message and pretend that it's coming from you. They can take over your WhatsApp. They can take over your Instagram. It happens. So I recommend agents to have a policy. As soon as you meet the client, I don't give or receive warrant instructions. You can choose the title company you want to work with, assuming that they are in the counties that they get to choose, or the seller chooses if they're in the other counties. But you have to deal with them directly, verify by phone. I will not be involved in any type of verification of wire funds. It takes a second for wire fraud to occur. So be extremely careful with that. There's no reason why you would have to assume that liability as an agent. It just doesn't make sense. Social media. Be very careful before posting to social media. Avoid misleading or deceptive representations and comments that could violate fair housing principles. As agents and brokers, you're accountable for your personal as well as your professional posts. So think twice and be sure you're not violating any state law or causing any potential backlash from anyone. Even if you have your social media accounts private, you are still an agent. They probably could still find it. So just be careful what you put out there. You don't want to be violating any ethical rules with your social media posts. You understand? Because everything is discoverable, right? So you don't stop being a realtor just because you're not showing a property at that moment. You always have, they're going to hold you to a higher standard, and you have to hold yourself to a higher standard and be really, really careful with that. So you're not being sued for something that you posted that may have been seen discriminatory. Or if you, now we're talking about FTC, the Federal Trade Regulation, for example, the Federal Trade Commission, they don't want you to do ads and make it seem like they're not ads, but in reality they are. They want you to disclose that within the social media post. So if you hire an influencer to do a tour of a house, to want to sell that house, that's an ad. It has to be disclosed within the influencer's page. And if you repost it, then you have to include your brokerage name and follow any other rules that apply when you are doing any type of ads as an agent. So just because it's in social media, it doesn't stop being an ad, and you still have to comply with all of the ethics standards of practice for making ads. Another thing I want to talk about before I go into the ADA website is, and I don't know if I talk about it later, copyright. Okay, so you can stop others from using stuff that you have copyrights on, and it does not have to be a registered copyright. So the copyright is an expression of an idea. It could be a drawing, it could be a picture, it could be a video, all of that. If you did it, you made it, it has your copyright, even if you didn't register it. So you can stop others from using that in their websites, in their social media, anywhere. If it's yours and you did it, you can send them DMCA notices, which are Digital Millennium Copyright Act notices, letting them know, not even letting them know, you let the website provider or the internet service provider know, and in Google as well, that a certain link is violating your copyright. And then whoever's using that image, video, will have a day or two to say that they have the license to use it. And if they don't, their content will be brought down. I use a DMCA notice to protect clients' pictures, to protect clients' videos. It's a very powerful tool. But you have to assert that you have the right to the copyright and that they're using it without your permission. I have used it when clients, when I say clients, I mean realtors, brokers, have, for example, certain pictures that they use for their property, for the property that they're selling, and then here comes another agent and uses those same pictures. That's a copyright violation, and we have taken content down. So be careful with that. Make sure that whatever you're using, you have the copyright, meaning you did it or have a license to use. And if you ever see others using your stuff, then there are ways to stop them from using it. Okay, we can take down videos, pictures, all of that, as long as you have the copyright, and it doesn't have to be registered. If it's registered, it's better, because now you don't even have to send them a notice, right? You can just sue them for 3 times the damages. So that, be careful too. When using images from Canva, from websites, make sure you have the license to use it commercially. Otherwise, you're going to get emails, you're going to get letters from law firms who claim they own their clients own the copyright, and they may very well, that might be the case. And now they're not telling you to bring it down. They're telling you need to pay us, settle with us, because you've been using this without our permission. And guess what? If they sue you in federal court and they have the copyright, you will end up paying. So be careful with whatever you use for advertisement. It's either yours, you created it, or you have the license to use it, okay? Now let's talk about ADA website accessibility. In Florida and other states, plaintiffs' lawyers have contacted real estate brokers and agents whose websites fail to meet the accessibility guidelines in the Americans with Disabilities Act. This is a federal law that protects people with disabilities. Accessible websites or mobile apps can interact with assistive technology, including software that converts speech to text and screen readers that display voice to text on a web page. Users should be able to navigate a site using just the keyboard if necessary. The ADA compliance requirements offer an opportunity for upgrades to sites to be sure everyone has an equal opportunity to educate themselves, search for homes, and make a well-informed decision. So there are many companies out there. I don't have any recommendations for which one. Do your research, see how much it costs, see what they offer. That will help you make your website ADA accessible, because you do not want to be violating that, because now a lawyer is going to come and sue you for that. To protect their clients, and it could be costly. And your website may very well be. Talk to your brokerage and see about that. Now we have the do not call registry, right? So every real estate agent should make sure every call is made if you're calling people personally without violating the Telephone Consumer Protection Act or the National Do Not Call Registry. All agents should avoid making automatic call, no robocalling, and be sure to leave a voicemail if no one answers. The National Do Not Call Registry should be checked before making unsolicited calls, preferably every 31 days. You must search 5 area codes at no charge. If someone makes a mistake, they should apologize and correct it immediately. The National Do Not Call Registry does not call businesses. Therefore, if you get a call from someone purporting to be from the registry, hang up. It is likely a spam call. Another thing I want you guys to be careful with is texting. There is another law that prevents people from texting and automatic texting, even your own clients. So whenever you have a client that you're signing up or a lead, make sure that your brokerage has some standard documents where they agree that you can use their image and likeness for your marketing purposes, where they agree that you can text them with updates and with information, marketing text, where they agree you can send them marketing emails, where they agree you can send them marketing calls. Like, make it a standard thing where a lead comes in, somebody comes in that you're meeting or remotely or by Zoom, and before you start showing them stuff, and along with the other documents that you have to make them sign, like your compensation agreement and all of that, you also make them sign this document where they agree to texting, they agree to calls, they agree to email marketing, they agree to all of that, so you don't face any issue down the road. That should be part of your standard procedures and practices. I mentioned copyright. We're going to talk about that again. So copyright is the branch of intellectual property that protects creative works. A copyright owner has exclusive rights that allow control in how copyright work is used by others. For example, using a photograph without permission in an advertisement or playing music without a license at an event may create liability for copyright infringement, okay? I'm gonna tell you something about music that some people don't know. I represent a lot of clients all over the state of Florida. I love to eat, I love good food. I like client restaurants because they feed me, it's fun. You are not allowed as a restaurant, well, any business really, to use music from YouTube, from Spotify, from anywhere for commercial purposes, unless you have a license to do so. So now you're probably wondering how you're gonna get a license from every single musician, from how you're gonna do it. It seems impossible. Well, there are companies, if you search, that already possess all those licenses. They worked it out with the different music providers, where they already have all those licenses, and they just license particular restaurants, particular venues, nightclubs with the usage of that work. Okay, so a lot of times restaurants don't know this. They're playing music, and then they get a nice little letter that says cease and desist, stop playing music, because you don't have the license to do so. And then when they come to me, what I need to do is basically negotiate with the license providers for this music, which is usually, big. There's 3 of them that are the biggest one, and negotiation type of contracts to where they're allowed to use that music, any music, for a certain fee, found out they're reusing the music. So you are not just allowed to use music for commercial purposes unless you have a license to do so. Be careful with that. For restaurants, it applies. For photographs, unless you took the picture or you have permission to use it, a license, you're not allowed to use it either. So, because all of that can create copyright infringement. Real estate professionals must be cognizant of copyright issues when it comes to listing content, most notably in connection with listing photographs. Improper use of listing content can create legal problems for agents and brokerages, because whatever you do, your broker is going to be responsible of. It is crucial to know what rights you own in photographs and how those rights permit you to use those photographs. To reduce your risk of copyright infringement, you should review photography agreements to assess what rights were granted or conveyed. Just because you hired a photographer to do your pictures of your listing doesn't mean you own the copyright. The photographer does. So whenever you're hiring any service provider to take pictures of videos, you want to ensure that you have an agreement with them where they give you full rights, not just a license, but full rights to those images and videos, and they will no longer have the right to use it. So don't assume just because you pay somebody to do it that you own it. It doesn't work like that in copyright. It's whoever created the work. So you need to have an agreement, whoever's doing your pictures, whoever's doing your videos, that they will give you the copyright, that they will no longer have it. There's some magical language that's called work for hire. So that way you own it and they can never claim copyright on it. Otherwise, they can give you those images and then give it to your competition too, and there's nothing you can do about it. Okay, so review the photography agreement, video agreements with your service providers to assess what rights were granted and conveyed, correct? Then you also want to audit your use of listing photographs to ensure compliance with the relevant agreements. Determine how you will use the photographs and ensure future agreements permit those uses, and maintain records of everything. All the photography agreements you want to maintain records of. I'll tell you something current that's happening right now. So we said, right, that real estate professionals must be cognizant of copyright issues when it comes to listing content. This is very, very true. On a recent case, this one just went to the Supreme Court. I'll tell you about it. The Supreme Court, and this is actually good for realtors. This just happened yesterday. It's when I saw it on the Florida Realtors magazine. The Supreme Court declined to hear a floor plans copyrights case, upholding a ruling that found their use in listing is fair use, ending 7 years of litigation. Okay, so basically, this is good news because that means that you can use floor plans in your listings, right? And what is fair use? So fair use is a legal exception to the US copyright law that permits the limited use of a copyrighted work without permission for purposes such as criticism, comment, news reporting, teaching, scholarship, or research, right? So there is a limited exception in US copyright law that says you can use copyrighted work without permission for purposes of criticism, comment, news reporting, teaching, scholarship, or research, okay? And it's determined on a case-by-case basis. Why is this important? So its refusal, right, to weigh in means the lower court's January ruling, which held that including floor plans in listings agreements constituted fair use, continues to stand and brings 7 years of litigation to close. This decision was significantly a major win for real estate professionals and brokerages because you use floor plans for marketing, appraisals, and other users. The defendants in that case received support from National Association of Realtors legal action program since the case inception in 2018. Since then, they have been fighting. So what happened? So floor plans seem crucial for information for consumers, right? A consumer wants to know what they're getting. So the case involved architects, Charles James, the owner of Design Works, whose home design was used to build 5 homes between 1996 and 2001, and was registered with the U.S. Copyright Office in 2018, because you can register your copyright. Real estate professionals Jackie Bulgen and Susan Horek each listed a home that used James' architectural design. Each prepared a floor plan for their respective listings, individually or through a contractor, and marketed the homes. The case centered on whether creating and displaying the floor plan of a copyright home design infringed on Design Works copyright. In January 8, the U.S. Circuit Court of Appeals ruled in favor of the real estate brokerages. In court, the NAR, the National Association of Realtors, explained how floor plans are crucial pieces of information for home sellers and buyers. Many home buyers rely on such floor plans in deciding whether to purchase property, and their ability to secure financing for that transaction is often contingent on an appraisal that requires a submission of a floor plan as well. And NAR amicus brief reads, on top of that, many localities require homeowners to submit floor plans before they can renovate their property. And when it comes time to sell, many Americans expect that they'll be able to use floor plan as a marketing tool to potential buyers in order to secure the fairest deal possible. This case now serves as precedent for other brokerages or agents who may face similar copyright claims. Think about it. The copyrights of the floor plans were legal, right? The designers, the architects, they copyrighted their work. They didn't want other people to use it. But in this case, the Supreme Court declined to hear it, which means the lower court's decision stand, which allows floor plans to be used by realtors as an exception, seeing it as fair use in this particular scenario, right? For marketing purposes and all of that. So that's actually a good decision for you guys in copyright law. So protect yourself. Quick takeaways. Make sure to disclose all information to all parties being represented. It is key to be as clear and transparent as possible. It is important to follow Florida law when it comes to advertising and marketing. No discrimination, Florida law, and also federal law. We just talked about copyrights. No possibility of liability for copyright and no frauds. Keep in mind the requirement needed to market your services, keep up with current platforms, and find innovative ways to advertise your properties. Consider getting professional liability insurance. It's also known as errors and omissions. Now, the more insurance, the merrier, but you need to understand the policy, because there is no point, okay, in basically getting insurance if you don't understand what the policy covers, right? So you want to ensure that you know what your policy covers. I'll give you a quick example. One of my clients had liability insurance, and she came to me because she was sued. She was sued because somebody went to her her medical spa, and claimed that they had injuries because of germs, right? So she came to me and she's like, Romy, look, this person is suing me. First thing I said is, let me see your liability policy insurance. She's like, yeah, I have it. Great, let me see it. And then what do? I read it, right? So my job sometimes when it comes to those situations is make sure the insurance covers my client. So I write a letter to the liability insurance carrier, letting them know this lawsuit, and you have to follow their formalities because they will tell you who to write, when to write, all of that. And then I get a nice letter back saying, no, we refuse to cover because your client had an exclusion, right, for anything dealing with germs. And I was like, what? Why would you have the exclusion? So I asked my client, and then they tell me, well, we had the exclusion because then our policy would have been cheaper. And I'm like, well, for saving whatever you save, $1,000 a year, now you're going to have to pay an attorney to pretty much represent you because the insurance refused to cover. So while it's good to have insurance, and I advise everybody to have insurance, that everybody that's in business, it's important to understand what the policy covers, okay? Because every time you decide to go into business, it's as if you're standing in I-95 and cars are gonna come at you, and you want to have some type of barrier that protects you. That barrier could be working under an entity, so that way, whether it's a corporation or LLC, and we can talk about that, and that barrier can also be insurance, liability insurance. And actually, even better, we have both. So realtors, right, Florida realtors are allowed to have that barrier and work under an entity. So while you are working or you are under your brokerage, right, you're still an agent, you don't have to operate under your name. You can operate under a professional association, which is a corporation, or a limited liability company. Real estate agents should consider my advice becoming a professional association. Why? Because that way you have a separation, right? So your assets are not going to come into play in the case of a lawsuit, because if they sue somebody, they're going to sue the entity that you were operating under, which is your professional association or the PA. So now there's a separate legal entity from you, right? The limited liability also, you're going to have that if you're operating under a PA. You also have certain tax benefits, such as pass-through taxation. Yes, it may require yearly board meetings, and we can assist with all of that, but it is imperative because it protects your assets. When you operate under your own legal name, then you're basically exposing everything you own. Now, in Florida, I advise to do a PA because the law for realtors only allow you to have one owner for your company. You have to own 100% of the company. And in the law in Florida is that a single member LLC doesn't give you as much protection as a multiple member LLC. But since as realtors, you could only have one owner, that is the reason why I recommend agents to form a professional association instead of a single member LLC to have more legal protection. Now, the name of your PA, DBPR allows you, and you need to be your legal name. So if my name is Romy Jurado, my PA has to be Romy Jurado. If my name in the license is Romy B. Jurado, my name has to be for my PA, Romy B. Jurado PA. You cannot put, most fabulous realtor, nothing like that. It has to be your legal name. So there is a process, and we can assist with the process to where now your license, it's going to be in the name of your PA. Your brokerage, it's going to pay you in the name of your PA. You're going to have a bank account for your PA where money from commissions are going to come to that bank account. And you're only using this PA for your commissions. Don't use it to own real estate, nothing like that. You're limiting your liability only to your commissions. So, and why also do I recommend to have a PA even if you have errors and omissions? Because errors and omissions may not cover you from fraud, breach of duty, breach of contract, negligence, bodily injury, property, some consumer protection acts that may apply, some escrow money disputes, misrepresentation regarding flooding or leaks, and misrepresentation regarding the value of the property. It might not cover your liability insurance. So that way you at least have that corporate bail if you're operating under a PA. And that corporate bail, once you incorporate, right, you are now considered an entirely separate and prominently distinct entity in the eyes of the law. Both you and your company are granted rights under Florida law, and the laws not only grant your company rights, but protect them as well by what is legally referred to as the corporate bail. The corporate bail is a legal concept that separates the personality of a corporation from the personalities of its shareholders. So meaning you as a person are not going to be responsible, your entity is going to be. And it's going to protect, you from being personally liable and for company's debts, for anything that the company does. It's going to protect your personal assets. Here is our information. That's my beautiful team. I think we're right on time. If you have any questions, feel free to ask. You can put it in the chat and I'll gladly answer. We have been doing this, I was going to say the law thing. I have been practicing for over 14 years, and I have seen a little bit of everything when it comes to ethical violations for realtors and liability, because anybody can really make a complaint in your association, and you might be able to go through the hearing ethically and see if you violate some ethical rules in your advertisement. But you also have to be careful about civil lawsuits or violating federal law when it comes to protections in advertisement. So if you have any questions or any issues dealing with any of those things, my law firm is here to assist you. We are based in Miami, Florida, but we do help clients and realtors all over the state of Florida. So if you have any question, our contact information is there. I'm very active on social media. We do have other videos in our YouTube channel and other things that we may help you with. So feel free to reach out anytime you guys have a question. It has been a real pleasure to give this class. I hope you learn a little bit of everything, and I hope to see you in our next class. Thank you so much. Bye-bye.